that I had seen him showing videos and that I was told that it was sexual videos of myself.
Revenge porn.
He sent this to my boss at 1:30 in the morning.
Very graphic email to her boss. Tell me why you sent that to her boss. Your last name is Self?
That's correct.
There are two parts to your claim. I'm going to get and take your hands out of your pockets.
Sorry about that.
I'm going to get and dismiss one of them and get to the one that is important. You and the defendant were in a dating sort of relationship. That dating relationship sort of continued for a while. At some point, you had an argument and she left you. She stranded you. That was in July of 2022. You say you had an argument, she drove off and she left you stranded. You had to get a hotel for the night. You had to pay a friend for gas money, blah, 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 blah.
Correct.
Forget that. That's what happens when you have a fight with your girlfriend.
Okay.
Have a fight with your girlfriend. How old are you?
I'm almost 40.
Well, for someone almost 40, they know how to get home.
Correct.
Okay, good. So let's get to what your lawsuit is. It's really about a phone that you say the defendant is responsible for losing or taking.
Taking. I have video to prove
taking. And the defendant in some way acknowledges that she disposed of your phone, and she says she had very good cause to dispose of your phone. She's going to tell me why. So I'm going to get some dates from you, Mr. Self, and I'm going to, at the same time, explore what I see is her answer and her counterclaim.
Okay.
Now, after the two of you had broken up, Miss Stroger was at a bar, and she was at a bar on what date?
I would say that would be the 16th. It was actually on the 19th.
August 2nd.
Was it August
8/2. You see how
She knows better about these dates than I do.
well, but it's your case.
I understand that.
So let's say she's right, that it happened on August 2nd.
Okay.
And at that time, the two of you were no longer dating or a couple.
Yes.
And you were going to a bar. And when you got there, was the defendant there?
Not that I was aware of at the particular time.
You didn't see her?
I didn't see her, no.
What time did you get to the bar?
I'd say about 4 or 5.
Anybody else at the bar?
There's quite a bit of people there, to be honest.
How many people?
I'd say about 30.
Anybody you knew?
Quite a bit of people.
Of the 30 people there, how many people did you know?
I'd say at least 10.
But you indicate when you got there, you did not see the defendant.
No, I wasn't paying attention to her at the particular time.
Well, you say that there were 30 people in the bar,
Correct.
10 of whom you knew, so you knew some people, and this was a former girlfriend of yours with whom you had been close association and intimate, right?
Correct.
And you didn't see her.
Well, they have a back patio, and then they also have the indoors and everything like that. And then they have a front area, too, as well, so.
Tell me, Mr. Self, when did you, in fact, see her?
It's when she was doing the bowling. And that was a little bit later on when I was playing pool.
About what time was that?
I don't know, probably like 7 or 8.
So you had been in the bar for between 3 and 4 hours.
Yes.
Okay, so now you're at the bar for 3 or 4 hours. And are your friends there, these 10 people that you knew?
Yes.
Now, I'm going to go back a little bit to the breakup that you two had.
Gotcha.
Was it a mutual breakup?
So what ended up happening and everything that we had a disagreement on the 23rd in Norco, and she left me stranded there, so I had to get another friend give me a ride back to my residence.
I can't understand a word you're saying because you're speaking too fast.
On the 23rd,
Better.
she left me at a barbecue and had a friend give me a ride back to Riverside, California.
A friend who was at the barbecue.
Yes, that's correct.
Okay, so you were at a barbecue with her,
That's correct.
and that was how far away from where you were living in Riverside?
I'd say about 20 minutes away.
And your friend was at the barbecue, and after you had an argument with her, your friend took you home.
Prior.
No, not prior. Is that what you just said to me?
In Norco, California, is when she left me at a barbecue. And then at the bar, or when we were down in Huntington Beach on the 30th, she left me. I have video that shows all that.
All right. I asked you whether the breakup was acrimonious. So one time she left you at a barbecue
Yes.
where you knew somebody who drove you home.
Correct.
And you didn't stay in a motel, you didn't do anything else.
didn't.
Okay, good. And then she did it again.
Yes.
Is that what you're saying to me?
Yes.
And the second time was when?
It was on the 30th.
Okay. And that is the time when you say you had to spend some time over. So after she left you the second time,
Yes.
is that when you no longer communicated with her?
That's correct.
Did you say, why did you leave me? How dare you leave me? You didn't have any communication by text or phone or anything else, is what I'm asking you.
So her cousin's supposed to play in a band. We showed up late. She was upset and distraught about showing up late.
Who showed up late?
We did, because I was with her.
I just need a date of that,
the
sir.
30th.
I have on the 30th, so she was upset that you showed up late, and
We showed up late to her cousin's thing. They're supposed to be at 2 o'clock. We got there about 2:05. She's upset about that. When we were driving down the road, because we're trying to find parking, which everybody was around and everything, she was getting upset and getting angry with another driver to the point where I had to pull the e-brake to stop the vehicle as I thought she was going to run into it.
And then what
I tried to
happened?
de-escalate the situation as much as possible. Mind you, there's 2 minors are in the back.
I would just like to know, was the breakup, I'm trying to figure out, was the breakup acrimonious or mutual on the 30th? Who broke up with whom?
She left me.
She left you there.
That's correct.
On the 30th. After she left you there on the 30th, did you have any communication with her?
I was done with it.
Just a second. So after the 30th, you didn't see her or communicate with her until you saw her on August 2nd, is what you're saying.
Yes. I didn't see her again.
Didn't see her again or communicate with her from the 30th of July until August 2nd, a few days later.
Yes.
Is that what you're saying?
I believe so. I can look at my records right now to see, but I don't believe I gave her a call or anything like that.
Okay. And when you saw her at the bar that you were in, you saw her later between 6 and 7. She was bowling. It's not an answer. The answer is yes.
Yes.
She was bowling. You were playing pool.
Correct.
And what this is about is your phone, which you're missing. So tell me about the phone, sir.
So I have a Note 10 Plus that was behind the bar at the time. Instead of going to my vehicle, which I typically charge it from that
Just a second. So you were charging your phone at the bar.
Correct.
When had you put the phone in to charge it?
Later on that evening, around 10, maybe 11, I'm guessing.
10 or 11?
I'm
Just
guessing.
a second. 10 or 11. So.
Because there's a few times I actually go in there, I charge it, then I use it for a little bit.
Well,
go back
but
there.
you saw it the last time.
I apologize for that.
Last time you saw it, you plugged it in. It was like 10 or 11. So now you've been in the bar from 4 to 10 or 11.
Yes.
And she was there, at least as far as you know, from about 7 to 10 or 11.
Yes.
Keep going.
So I charge it and
What were you doing with the phone all evening?
talking, texting, texting and stuff like that.
Texting.
Communicating, yes.
To whom?
Friends.
Friends.
What's going on, social media, all the good stuff.
Okay, go ahead.
So anyways, I was playing pool. I went outside, had a cigarette, and then that's when she, at 12:33 is when she ended up with her girlfriend looking around and all this other stuff. Like I stated before, I have the video that shows that on the camera. Would you like to see it?
So far, I'm not understanding you. So why don't you explain it to me, and then you can show it to me. So far, it's all a jumble. 12:30 at night.
12:33 is when she stole the phone.
Is when she stole the phone.
That's correct.
And you bought the phone when, sir?
About 2 years ago.
And how much did you pay for it?
I don't know, I think like $800, $700.
Well, this is your case. How am I supposed to figure out? You're suing for a phone that she took. How am I supposed to figure out how much she owes you for the phone if she took it?
I don't know how much I paid for it, but I know it retails for about $1,200.
Show me.
So I got the case cover,
What kind of phone was
the
it?
Note 10 Plus.
The Samsung Galaxy Note 10 Plus is typically $395 to $512.
At this point in time, yes.
Well, that's what it would cost you to replace it.
Okay.
Now, you do not deny that you put your hands on his phone in a manner in which you intended to have it removed from his custody, which means, according to you, you took the phone out of the charger and threw it in the trash or in trash someplace. So far, Mr. Self, the defendant acknowledges that she took the phone and trashed it.
All right.
And I want you to make sure that you answer my questions carefully. While you were at the bar between 7 and 12, did you ever show anyone at the bar a photograph of the defendant?
No, I did not.
Now I'll hear you.
So I got to the bar around 8:30 because I played darts that night. I did not see the plaintiff. I was playing bowling. There was an arcade game. And when he came in, he started showing videos of me.
That's incorrect.
Don't speak. Now, did you see him showing videos of you to anyone at the bar?
I saw him showing videos.
But didn't see what they were?
No.
I would never do such a thing. Apologize.
Could you stand up, please?
Absolutely.
Do you know Mr. Self?
I do.
Tell me your name.
Amy
Amy what?
Clack,
Were you at the bar on the 2nd of August?
I was.
And you know the defendant.
Yes, she's a friend of mine.
And what about Mr. Self? How do you know him?
As her ex-boyfriend,
Be careful of what you answer me. Did you see what Mr. Self was showing on his phone?
I did not see what he was showing on his phone. I saw him showing the phone, and I had friends who came up to me to see if I had seen it.
You can't tell me what your friends told you.
Understand.
You can sit down. Now, Ms. Stroger, your answer, and of course your counterclaim, involved the fact that Mr. Self was showing intimate pictures of you that he had maintained on his phone. So far, we don't have a witness to that. So what I want you to tell me is whether or not you personally had a conversation with Mr. Self about those videos on that night on August 2nd.
I asked him not to show video of me around the bar that night.
You did have a conversation with him.
Yeah, because he approached me.
Put your hand down. I want you to tell me about the conversation.
He approached me basically.
I don't want to hear basically.
He approached
Approximately
me
what time?
saying hi about 9:30 that night. Approached me saying hi. I told him I didn't want anything to do with him, that I had seen him showing videos, and that I was told that it was sexual videos of myself.
And what did he say?
He said he can do what he wants with his phone and walked away.
Do you recall that conversation, Mr. Self?
There was no conversation that took place. The only video.
No. Slowly. There was no conversation, that
whatsoever
took place.
that took place about anything like that. What video I did have was her being irate over there in Huntington Beach. So if you'd like to see that too as well.
No, I'd like to see the videos that she says that you have of her on your phone.
I don't have any videos of her like that on my phone.
Did you delete them?
I don't have.
Just a sec. Oh, he has a new phone. Got it. He has, just dawned on me, he has a new phone. Well.
I did have a letter stating that he did get the backup and he's got all the videos again.
Oh, I'd like to see that.
I do have a backup. Once I.
Just a second.
Okay.
He sent this to my boss at 1:30 in the morning. 2:43, sorry.
Mr. Self, this was sent by you to her boss on the 9th of August.
Okay.
Would you tell me the purpose of sending this letter to her boss?
She does very good at showing that she's a good person and all the other good stuff.
No, I don't think, listen to me. I don't necessarily think anything.
Okay.
I think any woman that allows photographs to be taken of her, intimate photographs that she would not want put on the, I'm speaking.
Okay.
I'm speaking that she would not want posted on the front page of a local newspaper.
Correct.
I think that that's foolish.
Yeah.
I do. And I know a lot of people do it. I do a shout out every once in a while and say that that's stupid to do. And I think certainly if you were showing those videos or those photographs to anyone at the bar because you were annoyed with her or whatever, you thought it was fun, I think that that's
Childish.
sad, maybe worse. What I want to know is, after this all happened, why you sent this email to her boss.
Because the thing is this, that she is trying to pin me as a bad guy or something like that, is what she's really trying to do. She's trying to manipulate it to be on her side. She lies and manipulates all the time. And I've seen that because I was with her. I should know. Okay? The thing is this, I have the video of her over there in Huntington Beach being irate, unable to have a conversation.
I don't care if she's irate, sir. Right now, she has no proof that you were showing videos of her at the bar that evening.
Yes.
You don't have that because that's your counterclaim. And if you don't have that, then I have to dismiss your counterclaim.
But there's also harassment and stalking that he's been doing.
Okay. I have to dismiss that part of your counterclaim, which is for revenge porn. Okay. Now, you're going to tell me about the stalking, and first I'll take a look at a police report.
The police report, unfortunately.
Just a second. If you don't have it.
I have a restraining order, and the police.
Just a second. Do you have a restraining order that's in effect now?
Yes.
I'd like to take a look at it.
Also, Your Honor, too, I have also.
No, I'm not.
Okay.
I didn't ask you anything. Were you at a hearing, Mr. Self, on this protective order?
I never even got served papers at all for anything.
I have proof of service.
Was there a signature on it?
Well, Mr. Self, she has a restraining order that's, and the hearing date was August 25th, 2022. She appeared. You're supposed to stay away from her. I'm just telling you.
Do me a
And I'm
favor.
telling you, considering the fact, and I don't know whether you were released from prison recently. Are you still on parole?
I'm on parole right now, yes.
Okay.
And he-
Well, if you're, I didn't ask you anything. Well, if you're on parole, Mr. Self, and you say you weren't served with this restraining order,
I was never
I would strongly advise, sir, that you retain counsel and question service
Yeah, I've contacted my probation officer. They're well aware of the situation.
Don't tell me what they're aware of. I'm telling you that there is a protective order in place.
Gotcha.
And if you want to vacate that protective order because you question service of that protective order, you better do so.
Okay.
In the meantime, I suggest you stay very, very far away from her.
He called me yesterday.
I called you yesterday?
Yes.
Don't speak to her. Tell me what the conversation was yesterday.
I was on my way to work and I didn't know the phone number, so I answered it and he said, please just give me a minute, and I hung up.
Did you call her yesterday from that phone?
There is a phone.
Just a second. That would be a yes.
Yes.
Okay, and you know
I was working
this situation is hostile,
Yes,
and you knew you were coming here today.
that's correct.
Would you tell me, please, why you called her yesterday?
I didn't mean to call her by any means. It's pocket dialed her.
Well, if it but called her or pocket
Correct.
dialed her, sir, that means that you were able to transfer all the information that you had on your old phone into your new phone, because after the experience that you had at the bar, there would be no reason for you to have her number in your phone.
I know.
Unless you just transferred.
I got it right here.
Well, if you got it, listen to me. If you got it right here, then it wasn't a butt call. So you can either butt call when, am I wrong about that? You know, I'm not technically sophisticated, but I do know this. I can't think into my phone. Now, maybe there is a phone that you can think into. I'd say, well, I have her number right here. I can't say, am I missing something here?
You might only butt dial me because I'm in your favorites, but
You called her. You want to tell me why you called her yesterday?
I accidentally called her
What's her number doing in your phone?
because I keep all the numbers and everything just in case I have to get a hold of somebody. Because you know how many times I've been with her and back and forth, back and forth, back and forth?
Yeah.
Tons of times. You know what I mean?
You know, sir, something, Mr. Self.
What's
I
that?
don't believe you, sir.
Okay.
I don't believe you, and I don't believe that there was ever any reason for you to contact her boss. I think she has an order of protection.
Okay.
I'd like to see proof of service. Do you have it?
Yes. Oh, it's not connected with that. I'm sorry. If not, I have a picture of the service in front of his house.
Yeah. Server's name. So it was personal service.
And I do have a video after the fact of what she's talking about, the individual coming to the house. So I recorded
I'm just
that.
reading the proof of service, sir. You said you weren't served.
I
I'd
was
like to
served.
see proof of service. If you had proof of service, you were served.
I wasn't served.
Okay.
Just because you take a picture in front of a house and everything doesn't necessarily mean anything.
Oh, yeah, it does.
Why is that? I wasn't even at the residence at the time.
They took a picture of me once.
Yeah, I would suggest to you, Mr. Self,
Stay away.
I would suggest to you that hire a lawyer.
Okay.
If you think that the service was improper, I'm satisfied with it, and another judge was satisfied with it, and I still don't understand why you wrote to her boss. Why you wrote to her boss afterwards. Any other communications?
To my boss, yes.
May I see it, please? Well, this is also written on August 9th, sir. This is from you, and it's a very graphic email to her boss. You want to take a look at it?
I do indeed.
I'm going to show it to you.
Okay. Thank you. So this is really just stating the individual that they hired,
Now, I'm just asking you whether you sent that to her boss.
that is my email address, and that looks
Yes,
like my
so-
writing. That's correct. Or
That's
my-
the question is, did you send that to her boss?
Indeed.
Okay. May I have it, please? And that was after the events, a week after the events of the 2nd of August, right?
Okay, yes.
You want to tell me why you sent that to her boss?
Well,
I mean, it's not telling that she's a thief. You have to be careful of her. It's talking about sexual things.
where is it saying sexual things in that?
Oh, very easy. You say she lies to her boss about cramps while we lay in
She
bed.
is literally taking off of work saying that she's, sick or this.
I'm asking you why. Why would you send this to her boss?
It shows that she lies and manipulates and all this other stuff to get her way.
Okay.
The fact of nature, I understand that I've been to prison and all this other stuff. I could be the bad guy and all that great stuff. I understand that.
I'm not saying she's a good person.
Correct.
I'm not saying you're a bad person.
Correct.
She's got to pay for her phone.
Yes.
You got to pay for this. Because I'm at a point where I don't actually believe that you didn't show some photographs of her around that
not.
bar. I don't believe that you didn't show some photographs of her around that bar.
I would never do such
Just
thing.
a second. Well, the same person who would never do such a thing wrote to her boss that you were present when she called her boss and said, I can't come to work because I have cramps, and she was laying in bed with you.
Correct.
Okay, and that same person wouldn't show a picture,
No.
No, okay, good. On your counterclaim, I am awarding you $5,000 on your counterclaim. From that, I'm taking off the $500 because he had no right to trash his phone. There are alternatives. One of them is not trashing his phone. Therefore, ordering on the counterclaim a judgment for the defendant in the amount of $4,500. Plaintiff's case is dismissed. We're done. Thank you very much.
She gets away with it again.
The judge is very fair. Unfortunately, he tried to make me look like the bad guy, but the judge can see right through him.
Did I show her videos? Yes, where she was being irate over there in Huntington Beach.
That he's showing sexual videos of me and him.
The nudes and all that stuff, no. Why would I do something like that?
I went black, and that's the only reason why I threw the phone in the trash in the first place, because I felt helpless.
She sold me on this great person and everything, but come to find out, you know what, it's not what it is.
I gotta just be more careful with their phone around.
It's because of my generation. But I've been saying for a very long time, even before the internet, because, you know, I was, in fact, young at some point in my life, and they did have all kinds of cameras and Polaroid cameras back in the day. But never take a photograph of yourself or allow a photograph to be taken that you wouldn't like to see on the front page of the New York Times. And now with social media, I think that that's more true than ever. To me, why would you post anything or take a picture, allow a picture to be taken that might later embarrass you?
I agree to an extent, but I disagree with you that in this case, because the defendant mentioned that the plaintiff had taken some of this video and photo without her permission. And I think that now it can get a little bit blurry as to, well, I didn't approve my photo taken. Obviously, a sexually explicit photo getting sent to your boss is not the intended purpose of that photo. I think whoever sends that photo, misdirecting the intention of the photo, is the one that should be held accountable, not the person that was sending it in for a purpose of a long-distance relationship. There's many reasons why now people might send photos that they wouldn't want plastered on the front page of the New York Times. But as the recipient of a photo like that,
you're not supposed to republish it.
You have a responsibility, if you care enough about that person, to keep its intended purpose private.
I absolutely agree with you. But it is bad judgment, so I don't mind repeating at least my perspective, which is, if you don't want to see it out there, don't take it.
Bro, this case started as a lawsuit over a phone, but it quickly turned into something much darker. David sued his ex-girlfriend JoAngela because she threw away his Samsung phone. He also wanted gas money and expenses because she had allegedly left him behind after arguments. Judge Judy immediately dismissed that part. And honestly, she was right. David was almost 40 years old. He was not a helpless teenager abandoned hundreds of miles from home. One time, a friend at the barbecue drove him home. Another time, he found another way back. That is not a serious civil lawsuit. The real issue was the phone. JoAngela admitted she took David's phone and threw it in the trash. Normally, that would make this an easy case. You take someone's phone, destroy it, and you pay for it. But then she explained why she did it. She believed David was showing private sexual videos or images of her to people at the bar. Now, JoAngela had a problem with her evidence. Her friend saw David showing people something on his phone, but she did not personally see what was on the screen. That meant there was no direct witness who could say, yes, I saw an intimate video of JoAngela. So, at first, it looked like the revenge porn part of the counterclaim might fail. But then David destroyed his own credibility. A week after the bar incident, he sent JoAngela's boss a deeply personal and graphic email. He wrote about her private relationship. He talked about her being in bed with him. He discussed her saying she had cramps and could not work. Bro, why would any normal ex-boyfriend send that information to a woman's employer? It had nothing to do with workplace safety. It had nothing to do with theft. It had nothing to do with protecting the company. It was designed to embarrass her. It was designed to damage her reputation. And it was clearly revenge. David tried to explain that JoAngela lies and manipulates people. He said her boss needed to know what kind of person she really was. But that is not his decision to make. An angry ex-partner does not get to contact your employer and expose private sexual information because he believes you are a bad person. That is harassment. And once Judge Judy read those emails, she started to believe that David probably had shown private content at the bar. Think about the logic. David kept saying, I would never show intimate pictures of her. But this was the same man who had no problem sending intimate details about her to her boss in the middle of the night. Those two positions do not fit together. A person who respects privacy does not send sexual and personal information to an employer. David's own email showed that he was willing to use private details as a weapon. That was the turning point in the case. Then we learned there was a restraining order. JoAngela had obtained an order requiring David to stay away from her. David claimed he had never been properly served, but there was a proof of service, and another judge had already accepted it. Judge Judy gave him very practical advice. If he believed service was improper, he needed to hire a lawyer and challenge the order legally. Until then, the order remained active. He could not simply decide it did not count. This was especially serious because David admitted he was on parole. Violating a protective order while on parole could create major consequences. And then came another unbelievable detail. David called JoAngela the day before the court hearing. She answered an unfamiliar number, and he asked her to give him a minute. David tried to call it a pocket dial, but Judge Judy immediately saw the problem. A pocket dial does not normally begin with, "Please, give me a minute." And why was her number still saved in his phone after all of this? There was a hostile breakup. There was a restraining order. There was an upcoming court hearing. There was absolutely no reason for him to contact her. David's explanations kept changing, and eventually Judge Judy told him directly, "I don't believe you." That was deserved. Still, JoAngela was not completely innocent. She had no legal right to throw away David's phone. Even if private images were on it, she had other options. She could have called the police. She could have reported him to the bar manager. She could have preserved the phone as evidence. She could have sought an emergency protective order. Destroying someone's property is not a lawful solution. That is why Judge Judy valued the phone at approximately $500 and deducted that amount from JoAngela's award. The phone was not worth the $200 David claimed. It was an older Samsung Note 10 Plus, and its replacement value was closer to $400 or $500. So, Judge Judy awarded JoAngela $5,000 on her counterclaim and subtracted $500 for the phone. The final judgment was $4,500 in JoAngela's favor. I agree with that result. David's original lawsuit was weak. His gas money claim was ridiculous. His phone was worth far less than he claimed, and his behavior after the breakup was disturbing. He contacted her employer. He exposed intimate details. He continued trying to call her. He ignored or disputed a restraining order instead of properly challenging it. And he showed very little understanding of personal boundaries. This case also creates an important discussion about private photos. Judge Judy's advice was, never take or allow a photo that you would not want published publicly. That is practical advice because once a photo exists, there is always a risk it can be copied or shared. But Sarah Rose made another important point. Sending an intimate photo privately does not give the recipient permission to publish it. The person who receives it has a responsibility to keep it private. Consent to take or send a photo is not consent to show it to strangers, send it to an employer, or use it after a breakup. The responsibility belongs to the person who misuses the content. The safest choice is to avoid creating private content that could later be weaponized.